I'm separated and about to get an inheritance. Will this be considered in my divorce? Hi, I'm Bill Farias, founder of Farias Family Law, and this is an issue that came up about a month ago. I spoke with a gentleman who is moving toward divorce. He's been separated for some time. Recently, and unfortunately, he had a parent pass away, so he's coming into some inheritance money, and he's concerned that his wife is going to get a piece of that. So the way that this works is that everything owned by either party, either individually or jointly, is in the marital pot for division. Now, that does not mean that everything will actually be divided. And when it comes to inheritance, gifts, a couple of significant factors are, number one, the length of the marriage. So the longer the marriage, the more likely it is that any amount inherited by either party is at the very least going to be considered in division. Number two, the timing of the inheritance. So there is a difference in the eyes of most judges between someone receiving an inheritance in the heart of a marriage, right? Especially if it's a longer term marriage, as opposed to someone receiving an inheritance at the tail end, when the parties are already split up, when the marriage is effectively already over. So those are a couple of key factors. Another factor is whether the inheritance asset or money is commingled with marital property. So if you want to optimize your chances of keeping inheritance money, first of all, a prenup is the best way to do that, but most people don't have a prenup. And so the second best thing you can do is keep those assets, keep that money segregated. The more that you mix marital money with assets from an inheritance, or the more that you mix any marital assets with assets that are inherited, the greater the risk that those assets are going to be considered for division. Now, they may be considered anyway. It really depends. I'll give you an example. If you have, say, a 30-year marriage and you had one of the parties inherit some assets in year 15, and these people have had an economic relationship throughout, there have been no significant splits in terms of time apart, and both parties contributed to the marriage, economic, non-economic, some combination. In that situation, in a long-term marriage where the assets are inherited at about the midway point, that's probably going to be in the marital pot, and it's probably going to be divided. Whether it's 50-50, that's at the discretion of a judge, but that's very different from, say, a 2-year marriage where the parties split up and are about to get divorced, the case is filed, and after the split, one of the parties inherits some assets, gets some assets from a parent that passed away. In that case, it is highly likely that a court is not going to divide the inherited assets and probably not even consider those assets in the division of property. So there are a number of different ways this can be treated. Again, on property division, the court has broad discretion, and by default, everything is technically considered, but there are some main factors that need to be taken into consideration. How long is the marriage? When was the property inherited? And was that property commingled with marital assets? If you have any other questions about this, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on Facebook and Instagram at Farias Family Law. Thank you. Have a good day.